Good morning. My name is Bob Wright, and it is my privilege to introduce our speaker for this session, Mr. Sheldon Stark. I've known Shel for a number of years, and in spite of that, I still love the guy. So the information in his bio is available, and everybody knows how to retrieve that, I'm sure. But there's also an article in an interview with Shel that Mike Lieb and I submitted to the ADR journal that is produced by the ADR section. And I commend that to you as well. You can find it on the section's website. The kudos and information about Shel are too great for me to take up any more time with this morning. But just this morning, it was announced that he is the 2023 recipient of the ADR section's Distinguished Service Award, which will be presented to him at the awards dinner on October 24. And if you haven't already signed up for it, I hope you will, because there'll be a lot of us there, glad handing and backslapping. So with that, I'm going to turn it over to Dr. Stark.
Okay, thank you, Bob. Let's get my screen up here. There we go. So I appreciate the comments and I love you back. So the mediator's job description lists many diverse roles. As to some, we act deliberately and intentionally, and we pride ourselves on how well we deliver them. As to others, we're only vaguely aware and self-conscious, and as a result, we sometimes may miss an opportunity to build a constructive environment for reaching resolution. And regrettably, as to still other elements of the job description, we're clueless, which hinders our ability to move the process forward. In this presentation, my hope is I'll present some important roles, that is, the key hats that we wear as mediator. I'll suggest a technique or two to enhance our effectiveness in each, and conclude with what I consider to be the single most important approach to the work we do, and I'll share that, and that is how expressly reframing the role of the mediator through a dialogue with the decision makers can create trust, gain party confidence in the mediator and her process, remove impediments to resolution, and maximize mutual party benefit. So let's start with, what's my line? In the 1950s, What's My Line was the single most popular television show. A panel of celebrities tried to guess the occupation of mystery guests using only yes or no questions. Our line of work is certainly no mystery to you or to me. I know what my job is. You know what your job is. But over the years I've been doing this, I've given much thought to recognizing all the many roles that we play. But what about the parties? Do they know what the mediator's job is? And what I've discovered is not so much. Exploring what parties expect from mediators, I suggest, is a useful technique to initiate your process. It's going to open doors and opportunities to make things happen. In my introductory, confidential, get acquainted ex parte meeting with decision makers and their counsel at the start of every mediation, I always ask about party experience with mediation. Have you been through one previously? Have you done anything to prepare for today other than speaking with your lawyer? Did you read any books or articles? Did you do a Google search? Did you go to the library? What did you learn? And critically, what do you expect from me as your mediator? What do you think my job is? And the answers are illuminating. Your job, I often hear, is to help us find the middle ground between our two positions. Or your job is to tell us the value of the case. Or you're going to help us reach agreement on what the case is worth. Or voice dripping with sarcasm and suspicion and skepticism, Your job is to make me take a whole lot less than this case is worth, or your job is to make me pay a whole lot more than this case is worth. Really? Are they right? Not so fast. While most cases do, in fact, settle somewhere in the middle, is that our goal? Is that what we're going for? And should it be? Are we pushing to reach agreement on the value of the case? Are we trying to make some crusty, jaded claims adjuster pay more than the case is worth? Is our job to persuade an injured plaintiff who lost an arm in a press accident or someone fired from a job she loved to take less money than the case is worth? Let's see if we can flesh out a more robust, comprehensive, and sophisticated understanding of the mediator's role. Let's start with mediator as host. Now, I'll admit right off the bat that an image from Game of Thrones and the Red Wedding is not the most suitable image for a talk on peacemaking, but I couldn't find a better image of a dinner party, ironically speaking. Whether you mediate at your own office or that of one of the parties or their lawyers, service as a good host is fundamental. Mediators must be thinking about such issues as accessibility for the disabled, physical safety, comfortable venue, ample restroom facilities, nearby parking, confidential and secure breakout rooms. I learned from a great arbitrator, Don Sugarman, many years ago that there was great value in managing food service. He brought bagels and cream cheese to every arbitration. Wow, what a concept. I saw firsthand the value of food, and I've followed Don Sugarman's lead ever since. Before COVID ended in-person mediations, I brought to every mediation a variety of fresh fruits, bagels and cream cheese, something salty like nuts or pretzels in the morning, and cookies and chocolate in the afternoon. Fresh fruit and bagels became my signature. Food is love. It's the grand oral equation. If I could get the parties to eat a little something, as my grandma used to say, I had confidence that case was going to settle. Unexpected food puts participants in a good mood. Many arrive at mediation in a rush, having missed breakfast, and they're often grumpy. Bagels and cream cheese changes that. Everyone is grateful. Fresh watermelon, grapes, strawberries, cherries. What could be better? And parties in particular don't get much sleep the night before an appointment, an important event like this in their litigation. They appreciate the unlimited coffee and tea service. Gratitude is a fine spice flavoring the mediation process and sweetening the atmosphere. Cheering up grumpy participants is an honorable, worthy, and effective goal. And having noshed all morning, most participants are happy to forego a lunch break. Lunch breaks can be counterproductive. There's a loss of momentum. Attitudes that were just beginning to turn positive may return to their original negativity. Over lunch, parties and counsel often crank each other up and crank up their emotions. They return to the mediation table impatient with the amount of progress and even less committed to finding a resolution. Food service is also a marketing tool. My refreshments, for which I never passed along the costs, were an incentive to hire me. Some of my market disclosed that they engaged me because they appreciated the goodies. Several asked during the Zoom period, could you not deliver those bagels to my office? Well, no, I couldn't figure out how to do that. I love mediating by Zoom. There's much to be said for it, but I do miss bringing in those bagels and carefully dividing even the grapes and strawberries into equal parts for each room. Okay, next. Mediator as educators. Mediators are nothing if we're not good teachers. First, I believe in teaching the process of mediation. Second, the benefits of resolution. And third, the costs and risks of not settling. Mediation is expensive. Attorney fees and half the mediator fees together with the cost of all the witnesses and parties who took the day off from the workplace to be at mediation can add up to a big number. And if the parties fail to reach a resolution, or they fail to learn something important and new as a result of the mediation process, it's been a costly failure. Mediation can be of great value even when a dispute doesn't settle. So let's focus on education about the process. In my experience, only a small percentage of parties conduct their own research into mediation. They rely on their lawyers, and their lawyers, generally busy litigators, rarely have time to fully educate their clients in how to get the most from the mediation process. Yet, understanding mediation and how it works is essential if participants are to get a reasonable return on their investment. Knowing the strengths and weaknesses of mediation helps shape how they participate in the process, what they learn, and how they make decisions. For example, to get information, parties reluctant to disclose must learn to appreciate the value of trading, give something to get something. Participants rarely understand that making a productive offer is more likely to result in a productive counteroffer, and vice versa. Crappy offers attract crappy counters. Crappy offers almost never send the message they think it will send. Instead, it says, I don't really want to settle. In support of the education process, I've posted numerous articles and links on my website to assist the lawyers in educating their clients and helping the parties educate themselves. Plug my name and mediation into a search engine and you'll find it. I've retired. I am not taking new cases, but I've decided I'm going to leave that up there for the next year or so at least, because I know there are a number of lawyers who encourage the participants in their mediations to take a look. So I'm going to leave that up. I can tell when someone has read an article on my website. They listen. They want to learn more, especially about their risks. They ask better questions. They have a deeper appreciation of the negotiation process. They enlist the mediator's help in moving forward. They're prepared and they're flexible. In that preliminary get acquainted introductory meeting I mentioned, I provide my 2 cents worth orally on how they might get the most out of the process, what to expect from me, and how they can best put me to use. For example, I've often said, we need to answer 2 big questions today. First, what is the best offer available today? To get that, we're going to have to make our own offers from this room to eventually get to a point where we can learn the best offer available today. And the second big question is, should you take it? Should you settle, and on what terms? Here's how the mediation process will unfold as we do our best to find the answers to those questions, and so on. I also remind them if the case doesn't settle, acquiring new insight and information should be the goal. I let everyone know bringing out all the information available is an important part of my process. And I explain why having all that information is so important. I want the parties and their lawyers to learn, among other things, the risks they face, the weaknesses in their own case, the strengths the other side brings to the table, the costs of not settling, both economic and non-economic, and the logistical nightmare waiting ahead if the case proceeds on. In other words, what must the advocates cope with in the event the dispute proceeds to trial? How can your lawyer do a better job for you at trial? Mediation is a great opportunity to learn the answer to those questions. What are the challenges and how are you going to overcome them? And in my opinion, the single most important piece of information the parties can take away in the event the resolution isn't achieved. What's it going to take to settle? What is the other side after? You all know this. Less than 1% of all cases go to trial. If the case doesn't settle at mediation, it's likely to be resolved short of trial. Maybe a dispositive motion, um, and maybe further negotiations based on what happened in mediation. What is the number that's going to close the deal? The case may not settle at the table, but knowing those numbers increases the likelihood the case will settle soon after. Okay, next, mediator as translator. No matter how much we encourage participants to choose their words carefully, or use the language of diplomacy, or refrain from making antagonistic or inflammatory remarks, rarely can they stop themselves. Moreover, parties are so often escalated and cranked up by the time they reach the mediation table. Hearing each other's claims and defenses only causes consternation and a desire to say something nasty in return. By reframing in neutral terms, a good mediator serves as a translator who can rephrase important messages in words that will be heard, and if heard, and this is critically important, considered. Calling the opposite party a liar potentially can turn the entire process sideways. But on the other hand, if that's an important part of the case, reframing that the other side has strong questions about credibility, and here's why, can result in a good conversation with the potential to make progress. In the first instance, the point is simply rejected out of hand. In the second, hopefully the party starts thinking about the point and it will have an impact going forward. Next role, mediator as guide to needs and interests. In my practice, my experience, most advocates and their clients view the litigation process in very positional terms, and the same for negotiations. Mediation, of course, is nothing more than an assisted negotiation. Parties usually know what they want and they know what they need before they agree to settle. Rarely do they think about the underlying needs and interests that might be driving the dispute. Even less do they consider the needs and interests of the other side. What might they need? What's driving their side in order to reach agreement? Moreover, when litigators and their clients make arguments, they're accustomed to directing those remarks to a neutral third party, a judge, arbitrator, jury. They're not trying to persuade their opposing party. Instead, they're trying to defeat them. Mediation is a very, very different practice and process in that way. And advocates are generally more comfortable in positional or distributive bargaining as contrasted with interest-based bargaining. It's helpful, therefore, to remind everyone as a preliminary matter that the principal audience needing to be persuaded at mediation is the party on the other side, not me. It's the party on the other side, not the mediator, who is the decision maker. That's an important component of the education process. And recognizing who must be persuaded should result in a major overhaul in how arguments are framed, words selected, positions described. I also work with parties in caucus to identify underlying needs and interests. If they are identified, sometimes creative proposals are forthcoming that satisfy what's driving the other side while still meeting your own needs. Winston Churchill taught us that the best settlements are those from which both parties walk away equally unhappy. But Fisher and Urey, in their seminal book, Getting to Yes, moved us well past Churchill's logic. Fisher and Urey teach that efforts to meet each side's needs and interests can often result in win-win solutions. Both sides walk away equally satisfied, if not happy. All right, next slide. Mediator as calming influence. I warned Bob Wright that I was going to say this. When I chaired the ADR section skills action team, I spent years trying to persuade my friend to do a presentation called How to Keep Your Head When All Those Around You Are Losing Theirs. And why did I want him to do it? Because Bob is a model for remaining calm and centered and stable and at peace. And no matter how much everyone else is cranking up and losing control, there's Bob Wright, totally comfortable in his skin. We must be role models, projecting confidence and optimism and calm. We must remain calm no matter what is happening. And that's one of my challenges. I can get aggravated, and I've found that meditation helps me stay cool. Participants do get impatient. People do get angry at the pace of negotiations. They sometimes lose their heads and threaten to leave. There will even be people who get mad at us. Crazy, I know. You're not doing this right, they say. You're not giving them the wake up call they need. You're not pushing them hard enough. Why are you picking on us? What about them? Yet and still remain calm. We must be like ducks, letting it all roll off our backs. Even if you agree that things aren't going well, even if you think there's game playing and manipulation at work, articulating your own angst and frustration and impatience is not going to make things better. Your aggravation is sure to pour accelerants on the fire. Keep calm and you will restore calm. Maintain the peace and peace will return to the room. Be patient and something good will happen. Remind people that it's still early and that many cases require the entire day to resolve. Remind everyone that some people need more time than others to process what they're learning. It's taken months, maybe years, to reach this point in the conflict. Conflicts are unlikely to be resolved in a mere couple of hours. And statistics are on your side. Less than 1% of cases go to trial. 85, 90% of cases settle at the table or shortly thereafter. Stay calm, be confident, be focused. Have confidence in your process. Be the role model everyone else needs to remain calm and continue a constructive process to conclusion. Mediator as negotiation coach. There are some outstanding negotiators out there. We recognize them pretty quickly. They have come to the table with an offer concession strategy well worked out. I admire the way talented negotiators execute a well-conceived plan to achieve their client goals. But there are far too many advocates who are not good negotiators. I've long suspected lawyers have forgotten how to negotiate, assuming they knew in the first place. Do I have to say it? A crappy negotiator is an impediment to resolution. A crappy negotiator is going to antagonize the other side and make your job twice as difficult. A crappy negotiator is not going to make productive offers likely to result in productive counteroffers. So, as a result, I believe negotiation coaching is one of the most important roles we play. I've written extensively on negotiation coaching, from managing opening offers to thinking and planning 5 and 6 moves down the board to packaging proposals effectively by structuring them in a logical rationale to make them attractive. And I often ask the other side how I often ask about a proposal, how do you think the other side's going to react to that? And I explore whether it might be time to try something other than what they want to put on the table. This topic is far too big and important to be covered very much here. So I encourage you to visit the articles and links page on my website for more detail. That said, let me say a few things about negotiation coaching. Before I present myself that way, I first asked to get permission. Would you mind if I push back on that? Can I make an alternative suggestion for your next move? I'm not going to tell you what to offer. This is your case. This is your decision. But I'm thinking that your next number might be more productive if it began, for example, with a 2 or a 3 or whatever. Chris Yates did that very well yesterday in the demo. And then I say, don't hesitate to say no. I have an advantage over you. I'm the only person who will be in both rooms, but I'll never know the case as well as you do. And if you choose not to follow my advice, I totally understand. I won't hold it against you, I promise. But if you want to make progress, I hope you'll be persuaded. Mediator as risk assessor. I think all of us recognize the importance of being an agent of reality. Parties and lawyers alike focus on their strengths and often sweep their weaknesses under the carpet. Out of sight, out of mind. We've all seen counsel who fall in love with their claims and defenses. You recognize it every time you point out a risk and they reply, yes, but Norm Tucker, one of the most successful plaintiff side medical malpractice lawyers, taught us some time ago, I think in Traverse City, that nothing settles a case faster than anxiety. Risk assessment is nothing if not a way to stoke up a sense of anxiety. Our job is to identify the risks facing the parties. It's up to us to make certain that the parties recognize their risks. It's our job to assist them in examining the risks and in weighing the magnitude of each. It's easy to dismiss a risk by simply acknowledging, yeah, Shell, anything is possible. But actually spending time and considering the risks and how they might impact the outcome, well worth the time and effort. For example, the judge has a long track record of granting or denying dispositive motions. How do you size up the risk summary disposition will be granted in this case? Or if the jury learns a party doctored material records, what are they likely to think? What's the impact of that? Will the jury thereafter believe anything that comes out of that person's mouth? I remember a lawyer telling me once in a race discrimination case that he wasn't too worried because his client used the N-word only once. Really? How many times do you think it's necessary for an explosive result? Another lawyer once told me in an age case that the list of dad's dinosaurs someone found on the copy machine, all of whom were fired once the son took over from his dad, was not a problem because no one would think dinosaur meant old. That lawyer needed a reality check. So for those of you who mediate with litigation and trial experience, your ability to identify risks and help parties assess the magnitude is a superpower, and it will stand you in good stead as a mediator your entire career. If, of course, but only if, you do it in an even-handed, symmetrical fashion. In the course materials provided, starting on page 7, I've tried to suggest a good list of topics to explore where you may be able to identify the most important potential risks in a case. Mediator as messenger. As advocates to ask advocates to identify the key roles of a mediator and messenger is going to be high on the list. First of all, of course, lawyers expect us to convey their offers and counteroffers back and forth. Second, lawyers often try to persuade us to deliver their verbal messages as well. Sometimes, if I agree with that message, I'm willing to do so. But if I don't agree with the message, I'll say so and ask for the opportunity to explain my thinking. No one ever refuses that, and suddenly you have a golden opportunity to deliver an effective risk message to the very advocate who's trying to enlist you in communicating his message. I call it mediation jujitsu. At some point in talking to one side, I may share the other side's message, but I'll try to present it in my own words, with my own spin, and consistent with my own assessment. I think lawyers can smell it, and their clients can smell it if you're saying something that you don't really believe. As to offers and counteroffers, over the years, I've experimented with urging the lawyers to deliver the offers themselves. I generally do this in two types of cases. First, the proposal may be so complicated and have so many moving parts, I don't trust myself to get it entirely right. In such circumstance, good lawyers are happy to do the heavy lifting there and generally agree to deliver that offer to the other side and then answer questions about it. The other situation where I encourage lawyers to deliver the number themselves is when the proposal is so ridiculous, they themselves don't want to be anywhere in sight when the offer is delivered. When I suggest they present such an offer themselves, they look at me like I've lost my mind. Exactly. That often makes the point and encourages them to reconsider their proposal. Most mediators are willing to eventually deliver even a non-productive offer. Me too, especially if I've pushed back without success. I place myself in that group. Occasionally they listen, and maybe we indulge them too much, Perhaps that's why lawyers have forgotten how to negotiate. They rely on the mediator to deliver a message they would never dream of delivering themselves. Perhaps the next bit I'm about to say would be better under mediator as negotiation coach, but I also suggest it's helpful if you can persuade them to wrap their proposal in a reasonable rationale. Look, lawyers are competitive. An arbitrary offer without a rationale will typically result in an arbitrary counteroffer, equally unproductive. The virtue of a rationale is that it results in a productive conversation about the reasonableness of assumptions. Here's an example. It's an employment case. Plaintiff is demanding $360,000. She's been out of work or underemployed for 18 months, and lost wages and benefits to date amount to $125,000. She was a big earner, and she's been unable to find a job with comparable pay. Plaintiff is then projecting future lost wages and calculates 3 years forward for another $150,000. Plaintiff adds $150,000 for emotional distress. Total number 4.25. Attorney fees to date, plaintiff says, are 25 grand. Now at 450. They contend that a good day in court for them, therefore, is 450,000. They're willing to discount it by 20% for the risk, and so the demand is now 360. Well, defendant isn't likely to pay 360, but imagine the productive discussion that follows. Has plaintiff adequately mitigated? Are the benefits properly calculated? Why 3 years into the future? Why not just 1 year? Should emotional distress be paid without a jury verdict? Is 25 grand for attorney fees reasonable? Let's talk about that 20% risk factor. We think it's 80% in our favor. Now, when the defendant is ready to make a counteroffer, all these issues may lead to a more serious and productive counter. As messenger, you've just added value to the negotiation process. Now, mediator is painter of the courtroom picture. What does the average party know about a trial? Not much, generally. For most people, their expectations come from the media. Did they watch Ally McBeal or Boston Legal? Suits? Did they see Paul Newman in The Verdict? I've heard many a party, plaintiffs and defendants alike, confidently predict how the jury will rule their way overwhelmingly once they've taken the witness stand and they've told their story. Overconfidence based on misinformation is a serious impediment to progress. If the advocate has trial experience, I ask them to paint the courtroom picture to her client. If not, I ask permission to do so myself. That's when I explain that no matter how good a storyteller you are, you do not get a chance to turn to the jury and tell them in your own words what it is without interruption. Instead, you're going to proceed by questions and answers. Your story may not be so easy to tell that way. And each question is subject to objection by the other side, which can totally disrupt that narrative and confuse things. Your testimony is then subject to cross-examination. And if you've been deposed, you have a pretty good idea about how punishing and potentially misleading a cross-examination can be. Are you vulnerable in some fashion to cross? Are there weaknesses you're going to have to acknowledge? What impact will that have on the outcome? And who else is going to testify? Does the other side have a parade of plausible witnesses who will say damaging things to undermine your claims and credibility? As a longtime employment discrimination lawyer, when the employer brings in a whole bunch of coworkers to talk about how tough it was to work with that plaintiff and how obnoxious they could be, that was painful. And it hurt with the jury. There are always two sides to every story. If their story is plausible, what's the risk? Some jurors will buy it. And let's talk about your belief the other side is lying. Have you asked your lawyer how difficult it is to catch someone in a lie, even when you know what they're saying is absolute rubbish? Do you know how many times it actually happens in a real trial? Not many. And now let's talk about painting the logistical picture. How long is this case going to take to try? How much time will you be away from your job? What is your boss going to think when you're away from work for a week or more? Have you even told your employer, your current employer, about this lawsuit? What are you going to tell them now? And you have a trial date, but what makes you think it's going to go on that date? What makes you think it'll be assigned even in the next 6 months or 12 months? How many times are you going to have to prepare for that trial only to have it adjourned? Settlement means the exchange of risk for certainty and money now. A bird in the hand versus two in the bush, and a way to close the book on an ugly chapter in your life. There's also a whole discussion around, does closure have value, and what is the value of closure? And finally, what do you know about the appellate process? If you win, is the loser likely to appeal? How long will that take? What's the risk of a reversal on appeal? And how much is an appeal going to add to the costs? Mediator is information exchanger. Often parties don't have the same pool of information from which to work. Especially in an employment case, the plaintiff rarely knows all the thinking that went on the employer side that went into the decision to not promote them or to fire them. Does each side have all the information they need to make a good judgment about whether to settle and on what terms? Are they aware of all the key facts and the documents on which the other side is relying? I believe the exchange of material information is among the most important roles we play. Here's what you're up against. You have an answer to it. How will you explain it? Sometimes the parties want an evaluation, a number from a neutral mediator that they trust. I recognize this smacks more of case evaluation or just judicial settlement than mediation, but most of us are market driven. We want to give our market, that is the lawyers and parties who use us, what they want. However, several words of caution. If they ask you for your valuation too early and they don't agree with you, you've given up your neutrality and you've lost their confidence. So if they ask you for a number, throw the question back in their lap. When they say, what do you think it's worth? The answer is, what do you think? And why do you think that? And no matter when they ask your opinion, it's probably safest to defer on the grounds it's too early. And I say, in my experience, we should be in rounds 5 or 6 before I'm going to ever be willing to put that oar in the water. You should recognize that if you're going to give an opinion, you're not a mediator anymore. Accordingly, I recommend expressly ask permission to change to an evaluator. And then I think it's important to clarify what they're asking is, are they asking for an evaluation of what the claim is worth or what the case should settle for? These are two very different concepts. Ultimately, my evaluation of the case will likely come as part of a mediator's proposal. Lee J. Berman famously said at Cooley Law School, I think a couple of years ago, that a mediator's proposal is a sign you've run out of good ideas. However, if you are someone who likes mediator proposals and you give them often, you should understand word gets out. Lawyers who know that that's how you do it are going to manipulate the negotiation process to be in the best position for a mediator proposal when you get around to making it. So be careful. Finally, if you're going to make a mediator proposal, be certain both sides have given you a clear idea of the limits of their likely authority. The better informed you are as to where the parties truly are, the greater the likelihood your proposal will be accepted by both sides. Mediator is crystal ball reader. Sometimes parties and lawyers ask us, what's going to happen? Sometimes we think we know what's going to happen, and sometimes we tell the parties what we think is going to happen. Should we be doing that? I suggest you consider removing crystal ball reading from your job description. This is a role you can play if, but only if, you have experience. And if you have experience, you should know better than to predict the future. Nonetheless, you're going to be tempted, and here are my thoughts. Projecting what a jury will do is very difficult today. Why? Because so few jury verdicts these days are out there to guide us. When I started practicing, we tried 20-25% of the cases. Today, it's fewer than 1%. So how can we predict? What's it based on? Moreover, how does your prediction of a trial outcome have any credibility if you yourself haven't tried many cases? On the other hand, most litigators have a pretty good idea about a trial judge's track record when it comes to dispositive motions. Here, we might be able to start predicting the future. There are often reported decisions, and predicting or at least exploring results can be highly productive. The strength of a case often depends on the quality of the evidence likely to present it. Let's talk about what are the strongest and most compelling pieces of evidence in the dispute. Now, what are the chances there will be a motion in limine to exclude that evidence? What's the judge likely to do with that? If the evidence comes in, what result? If it's excluded, what result? And how likely is admission or exclusion of evidence going to result in an appeal? And what's the risk that that exclusion or admission will be considered reversible error? More grist for that anxiety mill. Now we're coming to the denouement, the most important job of all. When that crusty, jaded claims manager or that skeptical, paranoid plaintiff tells me my job is to persuade them to pay more or take less than the case is actually worth, I reframe the role this way. No, that is not my job. This is your case, your money, your decision. Mediation is entirely voluntary. No one's going to twist your arm or withhold food and water until you cry uncle and settle. This is your decision. In fact, I make a joke of it. I tell them I have a pal named Lee J. Berman who underscores party empowerment with a good news, bad news story. The good news, he says, is I have mediated over 5,000 disputes in my life. The bad news is I haven't settled a single one. Well, the jaws drop open. The listener is stunned. And Lee J quickly adds, that's because I don't settle them, you do. Accordingly, my job is to provide you with all the information available today so that you can make a good judgment about whether to settle and on what terms. So, in summary, I tell them, I'm going to describe to you the other side's story and whether that story is plausible, because if it's plausible, there's a very serious risk a jury will buy it. We'll talk about the other side's perspective and their underlying needs and interests, because that will help you understand where they're coming from and maybe have an impact on how you package or make proposals. We'll examine the legal foundation of the claims and defenses. We'll assess the strengths and weaknesses. We'll recount the judge's track record. We'll identify risks and the magnitude of each. We'll talk about the potential jury pool. We'll paint the courtroom picture. We'll review the time frame, including how long an appeal might take. We'll consider economic and non-economic costs. We'll communicate the best number available today. We'll explore the value of closure. And with that, I am convinced your lawyer and you will make the right decision on whether to settle and on what terms. And with that, thank you. So it looks like we have some questions in chat. No No questions. So can we open it up to questions from the last few minutes? Bob?
Yes, we can. Thanks, Shell. That was fabulous. You're getting a lot of kudos. That's what's showing up there.
Thank you. I'm happy to see nobody's mad at me for using the red wedding image from Game of Thrones.
Any questions? You can either put them in the chat, the Q&A.
Yeah, I really want to encourage you. Go to my website. There are many articles. If you want to put them on your own website, you're welcome to do that. I am happy to give you permission to do that. All I ask is that you leave my name on the paper. But people who've read this stuff, it helps them know the process, take full advantage of the process, and increases the likelihood that there's going to be a result that everybody can live with.
Thank you is what we're getting there, Shell, in the chat.
Okay, well, listen, everybody, thank you. I've had a good run. This has been a good career for me, but I'm leaving while the getting is good. I don't want to be that guy that stayed one day too long. So
Shell
glad you were able
Larkey,
to.
sorry, didn't mean to step on you. I thought you were
Oh, go
done.
ahead.
Shell Larkey asks, what the heck is Rita going to do?
Rita's going to let me do all the cooking. Barb Johannesson says, briefly tell us your process steps, pre-mediation as well as mediation. So when I'm retained, I send out a letter to the lawyers inviting them to a pre-mediation conference call where we'll discuss a whole host of issues. In the conference call, I encourage them to, in preparation for the conference call, I encourage them to read the stuff on my website to see how I do things. During the conference call, we design the process to fit the dispute. I encourage the parties to exchange written material, and there are papers on my website about what I recommend for your written materials. After I receive the materials, I always create a timeline to help me sort of figure out the sequence of things. I draft a whole bunch of risk questions, common ground questions, consequence questions, and then I order them in a rank in which I think I want to follow them. And then I call each of the lawyers privately, ex parte, a couple days before we get to the table, but after I've read the summaries, do some follow up. You know, you all talked about the buy-sell agreement, but nobody's given me a copy. Can you send me that? You talked about catching the witness in a big falsehood. You didn't give me the transcript pages. Can you do that? Do you know what your attorney's fees are to date so I can talk about that? If not, would you do some homework on that? Tell me about your clients. What can I do to help you with your clients? And then I gather all this additional information. I then massage my timeline and my questions. And then the morning of the mediation, I meet privately with each side for this introductory, get acquainted session. I ask the parties how they're doing. I ask them their experience with mediation. I ask them what research they've done. I ask them what they think my job is. And then I ask them to tell me about themselves. I say, it's often I know something about you from the papers, but I don't know all that much. You could put it in a thimble. So it often will be important in the other room to know some things. So tell me about yourself, because I'm not going to easily be able to leave that room and come over and ask you. And then people tell me about themselves, and I get a pretty good idea of who they are. Family, education, employment history, what happened to them in the dispute, who they are, how they think, and what their concerns are. And then a question I learned from Zena Zameta that I like to ask there's one message you really want to communicate in the other room, what would it be? And then I start going back and forth. I encourage in that pre-mediation conference call joint sessions, and I argue, try to persuade the value of joint sessions. Sometimes I'm successful, but most Michigan lawyers don't want to do it that way. I do a mediator proposal maybe 5-6 times a year. I have other techniques that I like better. And again, you'll find those often posted on my website. So I hope that was helpful, Barb. Let's see, any others?
I think that does it. I did post the link to the interview that Mike Lieb and I had with you, that's on the State Bar website.
That was so flattering, and I actually sent it to all my kids.
Well,
and even Rita was willing to read it.
And if anybody's wants to know about his 4 careers he's retired from, it's in the article. Thanks again, Shel. We're going to end it here.
Thank you.